Very happy to have and welcome you to the Creating Safer Spaces, Setting Boundaries Through Education and Oversight. In this session, representatives from the FSBT Sexual Misconduct and Boundaries Committee will introduce a newly developed sexual misconduct education module designed specifically for students entering the physical therapy profession, as well as a set of regulatory resources aimed at helping jurisdictions prevent identity and respond to misconduct. The speakers for the session are Catherine Dower, Jason Kaiser, Samantha Mo Johnson. They're all members of the FSBPT's Sexual Misconduct and Boundaries Committee. You can find their bios on the event app. They have valuable information to share, and we encourage your participation. If you'd like to ask a session during the Q&A, the members of the Education Committee will be having microphones. At the end of the session, please scan the QR code to complete your evaluation. We really value your feedback. Now I turn the presentation over to our speakers.
Good afternoon. Thank you for joining us. Just to start, this presentation contains sensitive content related to sexual misconduct and professional boundaries in the healthcare setting. The material may include discussions of inappropriate behavior, trauma, and policy violations that some individuals may find distressing or triggering. We encourage all participants to prioritize their well-being. If at any point you feel uncomfortable, you're welcome to step away or seek support, and resources and support contacts can be provided at the end of the session. Thank you in advance for understanding and for helping foster a respectful and safe learning environment.
Thank you. Good afternoon. I'm so glad you all have your snacks and which we don't have, but we want to encourage you to go ahead and eat them. Eat and drink and enjoy. I'm Catherine Dower. I currently serve as a public member on this committee, and I want to thank FSBPT and the committee for including me in this work. And I want to do a big shout out to the board and to the staff and the early task force and committee members who really took the lead on this, because you were trying to get out ahead of a problem, and you're doing so in a really admirable way. Kudos to the members who, in addition to their day jobs and their families and their other volunteer work, get together on a regular basis. And this is one of those, I think PT is known for this, but it's one of those committees that gets work done. Like I went to the first meeting and there was no sitting around and talking about what we used to do, what we're going to do, what we're going to plan to do. We've all rolled up our sleeves and got doing it right away. There's a huge list of products that's already come out of this committee, and I'll share those with you in a minute. And we got a lot of work done this year. So I just want to acknowledge that because it's really important. I do want to shout out specifically to the Federation and to HRRI, which also supported and encouraged this work, and their websites already have and will have more information. So go to the FSBPT website or the HRI website. There's a lot of materials. If that's one thing you take away from this session, is that you will find something that you can use at work next week from the websites. There's a lot of material out there. And then as a public member, I always want to acknowledge that I really appreciate that. Those of you who've seen me come into meetings for the past 30 years, that's one of my passions, is to get public members on regulatory boards. I'm an attorney, I'm not a PT, I'm not a clinician of any stripe. But I have encouraged state regulatory boards and provincial regulatory boards to include public members. I think it's critically important on the boards and on committees. And I really appreciate having a voice, and I encourage you to keep doing that. It's particularly important in materials or efforts of this sort. So let me advance the slide and get going here. The committee itself, the aims are to increase awareness among the membership and among the public. In addition to the licensees and practitioners, we want to make sure that patients, clients, and the general public understand what sexual misconduct is and the impact that it has on the practice, on individuals and their families, and on the profession. We also the committee is dedicated to creating more resources. So we're all about developing and maintaining a comprehensive library of materials, really, that's tailored for physical therapy, but it can often be used for other professions. And I want to just call that out. PT, by getting out ahead of this, has created a name for itself, and other professions are now looking to PT, physical therapy, the physical therapy profession, as a profession that really is developing resources, developing understanding and awareness and materials that can be used. Much of this is not unique to this profession, as you can imagine. There's some tiny details that are unique to the profession, but many of the concepts can be shared and are applicable to other health professions especially. So you are being looked to now as leaders in this effort. So I really appreciate that, and there's a lot of resources out there that you can learn about. I do want to call out that it's not on this list, but the resources are not only for the licensing boards and licensees, which I know you're all working with all the time, but also for patients and for victims. If there are victims of sexual misconduct, there are materials for them as well. Okay, this is a messy, complicated slide, but the point is that there are a lot of materials out there that have been developed by this committee and the task force that can be used. You saw one of the videos today. It was shared earlier in one of the keynotes, which really was nice to highlight that. There's other videos on the website. There are webinars, there are documents, there are reports, there are surveys. It's really terrific, all the materials that are already out there. There's also some content that's been developed. So you can go to some of those messy things that like the green, yellow, and red. That's just a little snapshot of one document. You can use content that's been already developed with words that you can just copy and paste into your own materials. So for example, we have this little trifold that California developed, and it's titled Sexual Boundaries in Physical Therapy. This is a document for patients and clients. So this can be printed up. All the content is available on the website. You can copy it and paste it into your own format, however you want to use it. But it's really helpful because it says in layman's terms, you don't have to copy the Practice Act or your code or your rules, but you can have a list of what is not okay during physical therapy, and it lists it out for you. It's very clear, succinct. You can put that into any sort of document or website, and really it is helpful. We also did develop, and there's other versions for licensees and clinicians as well, of course. There's also an audit that was developed a couple of years ago that I worked on as a consultant that can be used by the regulatory boards to do a self-audit of your website to determine what you're doing or not doing, if there's areas of improvement that you can make to make it better and more user-friendly for patients, especially for licensees, to understand what sexual misconduct is, and if there is a problem, what's going to be done about that. So whether complaint forms are easy to access, whether there's policies that are clearly stated on there, how many clicks it takes to get to the page about sexual misconduct, if it's hidden away or if it's really upfront and easy to access. So that's a self-audit that you can download and access as well. So there's a lot of materials. I just want to make sure, we can't go through all of this today, but I want to make sure that you remember that you're aware of that. And then, as this committee focused, rightly so, on the boards and the regulatory reactions or responses to sexual misconduct, pretty soon it doesn't take long to become apparent that what we really want to do is focus on prevention, because we do need to deal with the problem once it pops up or once it's presented to us. But it'd be really nice to prevent the problem if we can. So to that end, we have several strategies, and one is to set clear expectations. The second is to develop education and resources, as I've been talking about. And then third, to make sure that we have enhancements, that we have improvements that can be made for systems. It's an ongoing process. There's no end goal in this that you're going to achieve at some point. You're not going to meet a certain point and everything's going to be done. So we're trying to make sure that you understand how we can set expectations and what they are for everybody, explicitly spelled out, have a wide range and a full library of educational resources for everybody, and have tools in place that you can continue to improve your systems, your institutions, your organizations. And it was in this context that this year the committee focused on developing an educational module. So this is specific to, hey, why don't we get this out in front of people in early days, as was just mentioned in one of the sessions, if people understand the issues of early days of their practice, of their professional career, they're more likely to continue those good habits throughout their career. If they learn about it later in the career, it's harder. So we developed this educational curriculum. Again, completely free to all of you. It's work that's been done by volunteers. It's available, it's downloadable. It's very useful and practical. So my colleagues here are going to be going through the components of it. And hopefully this will help prevent problems in the future by getting some of this information out to PT and PTA students while they're still in their educational phase of their career. But here's a little pro tip that it's not just for students. All of us can learn from these things. In fact, at every single meeting that I've attended, we all learned something from each other. So I encourage you to think before the end of the session, think about who else might benefit from going through one of these, just a piece of it or the whole curriculum, the whole module. So with that, let me turn it over to Samantha, who's going to go through the first components.
All right, so you get the fun stuff from me. Not really, it's really Jason. So why did we choose students and educators? Just like Catherine said, we wanted to get this out in front of folks earlier in their professional training. Just build good habits on the front end as much as possible. There are currently gaps in curriculum. Some faculty are addressing sexual misconduct and expectations and professional boundaries really well, and some programs are probably not addressing it at all. So there's variety in the content that's provided, in the amount of that content, and the way that that content is taught. And that variety means we have a whole bunch of people coming into the profession who have a variety of different information. And even if they have information specific to their jurisdiction, they might not, the jurisdiction in which they were educated, they don't necessarily have a good understanding of what's going on in another jurisdiction. And the importance of that once they enter practice. Another reason that we focused on this group is because it is going to impact this population. Students, there's evidence to show that students are they're at a high likelihood of experiencing inappropriate patient sexual behaviors during their clinical rotations. Up to 84% of students report that they experience some type of inappropriate advance from a patient. Additionally, we know that one of the greatest risks for inappropriate advances from patients during clinical practice is lack of experience. So the less experience you have as a provider, the more likely you are to encounter some of these kinds of experiences. Additionally, on the other side of it, understanding your professional identity and kind of how to execute those professional boundaries is something that people just have a lack of experience with. They're kind of still trying to figure it out. And right now what's happening is people are learning by trial and error. They're like, ooh, that was too far, won't do that again, right? So there's kind of that, ooh, that's maybe not the best way that we want to learn, because that's putting the public and our patients at greater risk, and it's using resources, all of your time, all of your efforts to protect the public, and it's not the way that professionals want to learn that information, right? The education that is out there right now is really focused kind of on that backside, the remediation. So, now you've made a mistake, let me give you this information to make sure it doesn't happen again. Or maybe that basic compliance level, we want to get depth. We want to provide kind of more standardized information that really kind of builds the professional and helps support them as they kind of go into those situations. Additionally, we've done a fair amount of outreach over the past couple of years. And one of the things that we're hearing from faculty in particular is they don't feel super confident with this material. That they maybe feel like they lack training or they lack specific experience with sexual misconduct in particular. And that they don't feel like they are necessarily the best person to present this information. And so providing some standardized, more specific information should be a helpful tool for faculty as well. So we wanted to design a module that was really flexible. We want programs to use this information, and we want them to use the information in a way that really supports their program. So our aim with this was to have a lot of different kind of areas of sexual misconduct covered in an adaptable design. So it doesn't have to happen in a certain order. It doesn't have to happen all in one course. It can be sprinkled throughout the curriculum. So faculty can really decide, like, how do we want to use these materials in our program, and how do we want to, implement various pieces of it. We also wanted to make sure that not only are we providing content, but we're also providing opportunities for educators to understand what learning their students are taking from it, so providing some level of assessment tool for the students as well. And then we know that students do better when they interact, they problem solve, they do some thinking and some talking, get kind of an emotional connection to the material. As much fun as reading practice acts is, probably case-based scenarios are going to be the best way to really implement or to really understand this information. So we really looked at kind of what are those basic evidence-based prevention strategies. So understanding the warning signs and what kinds of risky situations we can put ourselves in as professionals. Relationship dynamics, particularly that power imbalance between the professional and the patient, and then strategies for communicating with patients are kind of at the core central of the modules that we've developed. So there are several different components to the educator module. The first thing is aimed directly toward the educator. So we've put together a user guide that is essentially kind of like an executive summary of like, these are all the components that are here. Here are some suggested instructions or guidelines for how to best use these materials. We've also included suggested learning objectives. Like I said before, the assessment tools. So we have like a pre and post test that can be used. We have template presentations for several different kind of specific area topics. So we have professional boundaries, sexual misconduct and physical therapy, the power dynamics, patient-provider relationships, and then strategies for effective patient communication, duty to report, and then I know many of you were also next door during the last session with informed consent, and we're also including their materials with this module because they already did a really good job of defining all of that, so we're going to use their materials to support that. Additionally, we developed 9 different cases for students to work with or for faculty to work with. And each of those cases comes with suggested learning activities or different ways to potentially approach that specific case, discussion prompts to really kind of reinforce key concepts. And each case scenario itself will include a vignette. So, kind of here's the situation that's happening. And those are based on kind of realistic and common boundary violations and sexual misconduct cases that we as a committee have covered multiple times. I would say every time we get in a room, people start kind of chatting and I'm like, wait, no, that was in my state. And it's like, no, that was in my state. And so there's really a lot of overlap to the kinds of cases that actually occur. And so that tells us like there's certain information that should be shared out there. Additionally, for the faculty, because of that lack of confidence, we've highlighted what we think the key issues are that are represented by each of those cases. Some opportunities for students to make some decisions about the case that's represented to them. So what would you do? Or if you were on the licensing board, how would you proceed in this particular complaint? Or what could have been done differently? How would you have moved as a professional? And then we also share kind of the real outcome of, here's what happened in a case exactly like this. Here's what we thought the best example of that was. So, and then as I said before, pre-post assessments also provided to kind of look at the knowledge gains. All right, I'm going to pass it off to Jason.
It's kind of unfortunate that we identify this as the fun part. As part of our work, one of the things that we wanted to do was create scenarios for everybody to be able to use to kind of navigate through some of these difficult conversations. And I'll just say, with this particular vignette, that while the names have been changed to protect the innocent, the variables in the cases are real and collected and amalgamated, as Sam said, from all the different jurisdictions. So this being case number 5, out of what I believe right now is 9, and we continue to plan on creating more scenarios as we go through this process. We'll just start with this one. And this one's going to be kind of a back and forth for us, so I'm going to need everybody's help. But the situation is a patient receiving intervention for TMJ reported that during the treatment session, the physical therapist massaged her breasts without providing any explanation for the approach. And although the patient felt confused about the treatment, she assumed that the PT had a reason for using this treatment. So are we uncomfortable yet? Some key details as revealed through the investigative process. No chaperone was present during any of the patient's treatment sessions. Kind of makes that a little bit worse. The patient attended 3 additional sessions despite growing discomfort before canceling future appointments. That's a little confusing. That's a little odd. After discussing her concerns with a friend who was a nurse, another fellow licensee in healthcare, the patient filed a formal complaint with the state licensing board. All right. So, for the next portion, how should the board respond to this complaint? I'm going to do some of this kind of as a put you on the spot and showing the hands. We start with the assumption that the complaint and the allegations are true, and we investigate it as such until the fact pattern bears otherwise. I hope, right? That's my hope, because that's the way that it's being addressed. But for your jurisdiction and to your knowledge at this point, by showing of hands, have we opened the complaint? Yes or no? We've opened the complaint? Okay. Are there any of you that think that you wouldn't have opened the complaint at this point? And there's no, it's safe space, it's fine.
We want to create safe spaces here.
To Catherine's point, would you say that the process in filing the complaint was easy for the complainant? Show of hands? Yeah. I would say that the assessment tool that Catherine is talking about, to go back and look at your website and think about how deep this information is buried for your consumers, is an exercise that you will probably have to do multiple times. And it'll be revealed each time.
Is the complaint anonymous?
In this particular case, it was not. In your state or jurisdiction, once receiving the complaint, did you describe the complaint or the investigative process to the complainant? Show of hands. Do you think that you did a good job at describing what the expectations would be for the complainant at that point? Timelines, how much information that they'll receive during the process. Okay, that's some confidence. Were interviews conducted with the complainant? Or did you just stop at receiving the complaint? Interviews conducted? Okay. In your state, as part of those interviews, do you consider any kind of trauma-informed investigations as part of that interview? Like it's. All right. Did you interview the subject of the complaint? Yeah. The subject being the licensee. In this situation, in this particular situation. Okay. Do a review of the medical records. Yeah. hands down. The medical records were reviewed by an independent third party or an expert consultant. Okay, hands back down. The medical records were reviewed by a member of your board staff or even board members that are assigned to an enforcement committee. Interviews were conducted of any potential witnesses, including employers, employees, assistant personnel, other people that the complainant might have said could be. And any of these cases were escalated to a sworn level of law enforcement and may be prosecuted at a criminal level. Okay. In this case, at least for us, and the reason I'm familiar with this case is it's primarily built off of a California case. The subject explained that the treatment of the sensitive areas can be part of TMJ/TMD treatment, and that they always, and they emphasize always, explain that treatment and any approaches for sensitive modalities. This is contrary to the allegations made by the complainant. In fact, she said that she was never advised by the subject of any of the why of any of the treatments that she received, and certainly nothing that might have looked like informed consent. Now, where's the corroboration there, right? The middle road of corroboration is you go to the documentation, right? That's what we always have to default to. Our expert consultant then reviewed the case and found no rationale that supported the modalities and no indication of informed consent in any of the patient records. Right? One of the things that we do an outreach for both licensees and future applicants or students in programs is talk about how documentation is just as valuable for the licensee as it is for the consumer, right? And that informed consent should be documented in each and every instance and on a frequent basis. And here's one of those examples of, where we can look at the scales and determine if this is truly a he said, she said moment, or if the documentation corroborates one side of the other. What do we think in this situation would be appropriate discipline for a finding of this kind? Right? In your state, is this a revocation case? Show of hands. Assuming nothing more than what was provided to you today, no questions of previous history or anything like this, right? Revocation certainly for some, probation for others. So some remediation, some rehabilitation, some way to allow that person to continue in practice, but with assurances for the safety of the public, I'm assuming. Who gets notified of that outcome and when? For me, this is kind of an interesting question because in talking to a lot of you, I realize that some of these things aren't quite as transparent and public in process as they may be in some states. Right? So the outcome of this case in California was a revocation case. And in our case, who was notified first? Right? So typical in California is the actual complainant is notified of the outcome first. And then what we try to do, to the extent that we can, simultaneously, usually within a day or the next day, notify the respondent in the case of the outcome. And then, very importantly, and the third is public notice. Within, 72 hours of the final outcome, all of those documents, the accusation or the disciplinary documents, are posted to the board's website so that the public has that knowledge as well. But it's not a surprise to either the subject or the complainant. They were notified well in advance.
How does it go when you revocate a license in California? Does it actually take effect immediately, or is there a due process for that licensee that can go on for a long time? And how does that look on your web pages?
Yes and yes. Right. So
Can you repeat the question?
yeah. So what does the due process look like for my state when a revocation is put into place? And the question was, is it immediate? Does it take effect immediately, or is there a due process timeline, and could that be an extended period of time? I'm from California, so there's always due process, right? If the case is egregious enough, we will do what's called an interim suspension order that stops that person from being able to practice until the administrative action is carried out. That's a very hard burden of proof to meet and to have put into place, especially in a case like this. Once the revocation is set in place and it's adopted by the board, there's usually a time frame, what we'll call an effective date, 60 to 90 days before it goes into effect. And that is there primarily for that concept of due process. But due process doesn't stop there in that case. Even after the revocation is affirmed and the 90 days effect kicks in, they can escalate to a superior court and file a writ mandate and question the board's authority or ability to have issued that. Second to that is revocation for California is never permanent. 2 to 3 years after that revocation goes into effect, depending on the egregiousness of the charge, they can always petition for reinstatement of their license. They will come back for the same board. The composition of that board may have changed slightly, but they will have to bring rehabilitative and remediative criteria to that board, and that board will make a decision of whether the issue of that license is appropriate at that time.
So how long did this person practice after you made the decision?
So the question was essentially, how long did the investigation take? How long was that process there?
No, once you made the decision, were they out of practice that day, or were they practicing all that time?
It's typically 60 to 90 days, right? So they're served with the outcome of that, and then that effectively is 60 to 90 days down the road. And in this case, it was based on a stipulated surrender, right? So the way our stipulations are listed in this situation is a stipulated surrender as a result of discipline, right? It's not I just don't want to participate, but it is a way to mitigate costs for both the licensee and for the board in that situation. All right, you guys are great. I mean, you're all half asleep, but that's okay. So I will pass it back to Catherine. Future projects.
So one thing that I wanted to just kind of point out with the case here is you all have experience with the disciplinary process, with kind of how boards work, all of those pieces. So you can see that this content can be geared a couple different directions. It can be geared towards learning about regulation and learning about the disciplinary process and the different potential opportunities that kind of brings forward as far as student understanding. What are our responsibilities for reporting, activities of a peer and that kind of thing. The other thing that it brings up is on the professional side, how do I prevent this from happening, right? So maybe this PT really was doing something that they thought was absolutely appropriate practice. So for the students, what I might do is I might kind of point out, okay, what are the issues that this brings up? And I want to hear informed consent, absolutely, right? I want to hear that no explanation was provided for the patient regarding why this treatment would be helpful for them, or if there was maybe a different option available, like what's their comfort level. I'd probably call out the use of chaperones and when that might be appropriate. So I'm looking to get that kind of information from students in their discussion and really kind of facilitating what should they be thinking about. And then moving on to kind of this level of, okay, we've decided based on the fact that it's not in the documentation and, we've got whatever information we have from the various stakeholders that some kind of discipline is probably necessary, or at the very least some education is necessary for this person. And so then I'm going to go to the students and I'm going to say, what would you decide? And some of them are going to be emotional, right? They're going to be like, they should lose their license and we're done. They don't belong here. And others are gonna be like, oh, it's a mistake, I don't, like that doesn't really feel fair. So you can have them really interact with it and, look at practice acts and say, okay, what does the law say about this? What do our rules say about this? How could that help us guide our decision making in this process? So not only getting them familiar with the fact that these resources exist and that they're there to help us, but also kind of getting them interacting with them and thinking about how you might apply them in a real world situation. So that's just a way that I might approach that a little bit differently with somebody who doesn't have that experience with, exactly this kind of situation, which would maybe be a little bit different than a group like you guys. Yep.
Thank you. Dave from New Jersey. I struggle with this scenario a little bit. Let me explain. First of all, I'm a clinician and I treat TMD. And I would never massage someone's breast when I'm treating their TMD. However, there are some procedures in which you might be close. Pec minor release, first rib mobilization. So in this case, the informed consent needs to be really specific. And I would explain it to the patient. And in this case, I would probably list the things I'm going to do and put it in writing. So we had the conversation, and this is what I talked about. And if you're on board, I'm going to do these things. But I'm not going to be massaging your breasts. That's not appropriate. But I think that's where the tie-in comes in between the informed consent lecture. That sometimes you have the conversation, but you don't have anything in writing. And if it's not in writing, for the lawyers in the room, it didn't exist. So I'm just thinking for these kinds of scenarios, it might be a good idea to do some specific written informed consent.
I want to comment on that because I really appreciate it. I am an attorney, but I'm also a member of the public and a patient. And I think that the patients will really appreciate hearing that from providers that you want to document informed consent. Because I think that hasn't been the case. I mean, most of us, right, we go in and we sign that thing in the waiting room at best, and we're not trained as patients to expect a real detailed conversation back and forth, much less a document, written document with a list of things as you suggested. I just want to call that out, and that's one of the things I appreciated about the trifold that you put together in California, Jason, that what patients can expect, like what's kind of normal and what's not normal, and add to that list really clearly an informed consent conversation, a discussion between the two of you that then is documented in the medical record. I think it's a really good call out for the practitioners as well as for the patients. I think that's a benefit.
Yeah, to your point, I'm really bummed out that I didn't get to see their presentation today, but I'm sure that consensus in the room would say that depending on the sensitivity or the nature of the treatment, you would kind of ratchet up not just the level of detail that you would document in informed consent, but maybe the time frequency in between when you check in. Are you still, are you comfortable? Is everything still okay? Do you still understand? And in this case, that's one of the things that we were talking about. That's the corroboration difference, is that there was an absolute lack. Well, I will tell you, there was probably just an absolute lack of documentation altogether. And California has some of the highest documentation standards for PT. I was conceived. The fact that there was none whatsoever was telling, right? And that best advice, that best practice advice that we give you as the treatments are more sensitive, that we would expect a higher level of detail, is based on a community standard, right? It's based on what an expert consultant would opine and provide to the board report.
One additional detail that I would say, based on your comment, is it also allows students to use like their exam and eval knowledge, their intervention knowledge, and say like, why would anybody do that? Is there a reason to massage somebody's breast? Or why, what might be perceived that way, and how could I better explain it? So they get that practice actually having those conversations and figuring out how to explain what it is that they would do in, a given scenario.
Jason, in this particular case, or any of you, what would be the discipline and remediation Unfortunately, I'm from Missouri, we've had more than enough of these sorts of cases, and I'm just kind of wondering what you all kind of compare with what we've done.
Had the licensee in this situation not agreed to surrender the license, just based kind of on the principle of the case alone, I probably wouldn't have agreed to any kind of stipulation involving probation. I would have had to let that go to an administrative hearing. That was kind of, my board member just stepped up. Man, that was kind of above my pay grade. Just as a matter of principle, I wouldn't have negotiated anything less than a revocation or a surrender. Changing the variables slightly and considering maybe that there's something that would sway me in a way. The conditions that I would probably put in place would be something like a mandatory chaperone or a prohibition of treating specific patient populations, education courses involving boundary issues and assessments by practitioners for.
And that's my question. The ones we've had, we have usually given them probation and they're under supervision of, in this case, it would be another female in the room when they're treating for 3 to 5 years, plus an ethics course or boundaries course. We usually use the APTA ones. I saw that you're preparing things. Does FSBPT or something like that? We could require them to pay for and complete, and then show completion to our board before we release them.
So I don't think FSBPT has anything in the works of developing those types of programs themselves, but in the materials and the resources that this committee's already created, there is a list of available, what we would say have been vetted and are well-performing courses, and they vary in affordability. Some can be very expensive, but some are cheaper. Absolutely, right? Well, you get what you pay for.
Right. Thank you.
I have a question that is a little bit of a twist on your scenario. Because I understand about the revocation, but along with revocation comes our inability to regulate them for future bad acts. So my scenario twist is that it's a PT-owned business. And the PT that did the egregious act, I'm going to call it an egregious act, owns that business. So if you revoke their license, but then through hearsay, but yet nobody has filed a formal complaint, like, how do you handle that situation? Now, where do we go forward when we know we have heard through the grapevine and we know we're all very close, tight-knit community and we hear things? How would we handle something like that? What is your advice in handling something like that?
One is, I would say, consult with your attorney to find out what your employees are understanding. The second, I would say, is it's not always a good idea to follow what I do. Right? And then thirdly, I would say, and we do this as kind of a regular practice, is that, and it's the scenario that you spin has happened to me multiple times in my career where I know that through that revocation, a very prominent practice owner, multiple practices, that kind of thing, is still going to remain the owner of that practice. And some of those bad acts, whether they are boundary issues or sexual misconduct, maybe they're billing fraud or that kind of thing, could still well be prevalent and still be committed as just being the owner of the practice and never touching a patient again. This board can put a calendar reminder to do an on-site visit of that practice, periodically, just to make sure that those things are in place, for one. In a case like this, though, the surrender that gets put into place, if we ever got an inkling of any kind of behavior still happening involving even past patient-practitioner relationships, right? Now, what authority do you have at that point? You've already revoked their license. They would definitely come into the equation if a petition for reconsideration or a petition for reinstatement of that licensure was ever filed. We would have that in the investigative file and we'd be able to share that with the board for their consideration.
I just kind of wanted to swing back to the documentation for a minute because I think we all use AI in some form and the programs that we use. And I think we need to be very intentional with staff. Just because they can close their eyes and punch and click and there's lots of choices, I think that's an intentional step that we need to take in training staff, that just because it's not in the program, it doesn't mean that it's wrong to put it in your note. I think there's a lot of people out there, I deal with documentation all day in my world, and that's the response I get. I don't have that choice. Now, sometimes we can find a better program, but again, I think it's on us to, provide that heightened education, because I think everyone in the room probably knows what should go in, but the average person, they need that jolt. Just to say it's not there, let's not dummy it down. I think that's just one important thing, especially with students that are going to be exposed to a lot of different, systems, to really hit home, because I don't think they understand, again, the importance.
It's an excellent point, and I was going to say from the administrator's perspective in the room, but I'll just limit it to my own perspective in the room. I realize that electronic EMR is convenient and necessary and provides for you as practitioners an easier way to do your job. From an administrator's perspective, it is the bane of my existence. All right, so one of the things that I'm always looking at, and harping up to your point, is that as licensees, you are still responsible for the documentation itself, even if the software engineer who wrote the EMR didn't write it for your particular jurisdiction and the requirements in your jurisdiction, and it's a national product, and and it is a cut and paste or a drop-down menu or any of those kind of things. From our perspective, my emphasis is if you can't figure out how to make the requirement fit somewhere inside of that EMR, write it down and put it somewhere where my investigators are going to find it. Right?
Lisa from Pennsylvania, you mentioned a little bit about the criminal side. And I just was wondering how other jurisdictions do it, because I was surprised the first time we had, and our attorneys do most of all the work. The board doesn't do too much in this part, but we had a similar case. The recommendation was 18 months suspension. And I posed the question, well, what about the criminal side of it? And the attorney response was, that's up to the complainant to decide it. And I feel like that's a little bit, to me, deceiving to I think the general public might think if I file a complaint with the board, then they're going to decide that they would recommend. And I just was wondering if that's the way it is in most jurisdictions, or?
That's a really good question. I did a lot of research to look at different professions, how they handle complaints about sexual misconduct, and different fields too. And it's interesting that there's only a few that have a clear landing page for patients or clients or the general public to list out all the different options and the pros and cons. And because I didn't see anywhere in any regulatory boards, information that, well, this is what we could do, but you should also know that you could do this. You could file a criminal complaint, or you could do nothing, and this is what's going to happen. Like, it was really interesting that only one, I think it was one of the therapy groups, said, here's the different scenarios that you can, or different pathways that you could choose, and here are the pros and cons of each one. And they were very clear, and it was relatively objective and unbiased, because they didn't really have any skin in the game. They said that the regulatory boards, the pro would be that maybe you'd get the person's license revoked at some point, but the process was so long and so ill-informed generally for the complainant that it often was difficult. Whereas a criminal complaint, you might get restitution and you're going to be protected by the laws. And it was just very interesting. I just want to call it out because I didn't see any boards ever saying, thanks for calling us, but do you know what your options are? Because if you go this route, it's going to take, maybe a year or more, and you're going to be exhausted, and you're going to be not, being able to pursue your criminal complaint if there is one. So you should check in with somebody. It was basically the bottom line. I talked to somebody because there are pros and cons. So I'll just stop there with my perspective on that. It is really important, though.
I'll say there's a matter of sequence, right? So typically, in my experience, we are made aware of that situation based on a criminal complaint. right? The majority of the time, there are rare instances where the complaint comes to us first, and there are some bridges there when it comes to, our analysts, our investigators are going to ask questions, with undue influence in asking, have you filed this complaint with local law enforcement, right? There's also a jurisdictional duty here. The only book that I have to enforce is your Physical Therapy Practice Act. Now, I can prosecute any of those up to a misdemeanor, right? I hope that the local district attorney will address that situation, should it be appropriate, using the penal code and all of the aspects of the penal code so that, due process is fairly served. But I have an obligation at times to say, okay, this is unprofessional conduct, but it's unprofessional conduct that escalates to the violation misdemeanor. I'm going to seek out a district attorney to work collaboratively with me in that process.
Scenario for you, Claude Tremblay from Louisiana. I'm a licensee. I look up to you to give me some general guideline from a legal standpoint and from a clinical standpoint. If I am to treat a patient and there has to be some documentation in place, how do we ensure that there is continued consent from the patient unless you are telling them every single visit, you need to sign on the dotted line that I've explained to you what I'm about to do, how I'm planning on draping you, that I gave you an opportunity to request a chaperone or to skip the treatment altogether. How do you document that without being just an exhaustive process if you have some of those pull-down menu software, which, I have enough gray hair, I know how much of a pain in the story.
I'll concede that it may be an exhaustive process, right, in your documentation, and there may be some boilerplate and template language to it. But I'd also ask you to practice it, right? So if it's documented, it should be part of your normal routine in doing it. And I think that was probably mentioned or brought up in the informed consent today too, is that, and even to the topic that we were talking about earlier, the more sensitive the modality, the higher the level, the higher the caution, the higher the level of documentation involved in doing it. It ultimately comes down to a test of law in that situation, right? Your documentation, hence the term defensible documentation, would be yours, right? What are you comfortable with as a practitioner? You'll find you'll find requirements of documentation, but you won't find how-tos in the documentation when it comes to regulations, because we would be writing regulations continuously until the end of time. You work in so many different clinical settings and so many different practices, utilizing so many different products, this EMR, that EMR, still on paper, or even a proprietary software that you've created yourself. As long as it actually tests against the investigation, and those are the things that I want you to consider is, should a complaint be filed against you, does your documentation tell the story of what happened that day to an outside perspective, to an investigator in that situation? And would it be defensible for you? In this case, just the absence of documentation gave corroboration to the complaint story. I mean, the modality is so sensitive that I would expect any of my California licensees to at least have documented a minimum of informed consent. So the absence was glaring.
To that point too, looking at the consistency in documenting informed consent. So if a provider clearly is documenting informed consent for all of their other patients or all of their other interventions, but they conveniently skip it in this particular case, that could be a little bit of a red flag as well.
And if you have a clever investigator, that will be one of the things that they look for is, treatments of other patients surrounding that certain time frame and were they consistent from one patient to another? Was the documentation anomalous in any way?
And I would just finally add, if there's any significant change, you have to document it. If you're not changing anything, you have a little bit more leeway to, if you just saw the person 2 days ago and you're doing the same exact thing and their condition hasn't changed, you have less of a problem if you don't document it again at that time. The longer amount of time between the sessions, and if there's any significant change, the more likely that you will need to get informed consent again.
Hi, my name's Megan. I'm from Virginia. And this is kind of a random, scenario, but we're talking a lot about documentation, and I'm thinking about students I've had in the clinic that feel like they have had instances, of inappropriate behavior, and there is no documentation because they're not a patient. And the power dynamic there is also a struggle. So I'm just looking for maybe some advice or insight into how I can coach students, not to look for it, but be empowered to report it.
SMBC resources, but I'm gonna let Samantha speak to that one, that's her specialty.
I absolutely, I think that's part of the reason for providing this educator module is because if students are informed, like, hey, this is something that is so likely to happen to you during the next year, we want you to be prepared for it, then they're more likely to be willing and confident in saying something, right? And saying something to their clinical instructor and saying something to the site coordinator or to the academic staff and to say, hey, this happened, it's not okay. A, I need support. And B, what do I do? Or if it's a more of like a sexual harassment between, them and a peer in the clinic or, their clinical instructor that by providing this information and giving them clear tools to work with, that's going to help kind of with that advocacy. At least that's the goal.
To address your point of there being no documentation, and this is just general advice for any type of offense that may ever occur to you in your life, whether it be administrative or criminal or civil or what have you, documentation can always be defensible. So if you're able to document, take notes, that you can use to recollect, refresh your memory, timestamps, right? So no one could ever look at you and say that you were so Machiavellian that you just journaled this all up as a mastermind. You documented it in the moment, especially for that student and clinical instructor relationship. Be prepared, say something to your clinical instructor, bring it to the site coordinator. And we had addressed this in another session. As regulators, we're sensitive to the shortage of clinical sites, but it's meant to be an educational experience. So if there's a situation like that, we would want you to address it at the lowest level possible. But at some point, that should come before the board, and we should be able to take a reasonable sanction against that.
Just a comment on that and then a question. For some schools, that would be a reportable offense to Title IX to your dean of students. So that has happened and it's a reportable offense. And I know in Massachusetts we're mandated report as educators of that. So that's just a comment. Are these modules up on the FSBPT website now with the case studies?
So they're not available yet, but we're working on finalizing everything and it'll go to the board of directors for approval. And then the plan is that it will be released on the educator page for FSBPT. So at least your program director, sometimes like your DCE or a couple other people will have direct access to those modules, and you should be able to download everything.
Great, thank you.
But the resource for patients,
Yes.
practitioners, and the public are already available.
As well as the videos.
So just to follow up on it, because we had a case in Colorado recently where a CI was stalking a student, and we were told by our AG, because our Practice Act doesn't include that, it specifically discusses sexual harassment on patients. So I encourage everybody to look very carefully. We had nothing we could do to punish that person. We had to refer it to the school, and the school certainly could take about it, and it could be a civil complaint between that. But that student, we couldn't discipline the PT for their acts because it's not in the Practice Act. And that's something we may need to look up in the future, but I'm sure most Practice Acts may not include that.
One of the most beneficial tools that I have in our Practice Act in California is the general label of unprofessional conduct, right? So when it's not something that is specifically cited in regulation or in statute, but it falls into that gray area of what we call community standards, and it will become at some point a battle between expert witnesses. But unprofessional conduct is unprofessional conduct. It's kind of like that famous, descriptor is, you know it when you see it.
So we have one last kind of question for you, which is, we want to bring things back to the boards next. We've kind of taken this brief interlude where we really focused on educators and students and kind of the prevention components, but we really do want to get back to making sure that we're supporting you with additional resources and kind of focusing our time towards you. So any recommendations, definitely feel free to pull any of us aside or anybody else from the committee to discuss thoughts that you have about how to adapt these modules to use for your boards or your administrative staff, and any other ideas that you have for resources from this committee, because we are definitely open to hearing about it.
Okay, Janice from Kentucky. I would say a really nice train-the-trainer model for the boards, and then allow the boards to provide this education as a free CE and get continuing competence units for it would be perfect.
From California. I think in terms of adoption, I've heard great comments about like what an expert TMJ practitioner might do. So maybe the module would contain some alternative like strategies, or in this situation, it was dealt with this way, but how would you deal with it if it was per an expert who said that they would do like pet minor stretches and so on. So just kind of maybe looking at expertise around those cases and throwing out those, as an educator, I think throwing out those scenarios about, well, you can't, like you said, you can't prosecute this way, but you can ask the school to do something else, so that educators are aware of some other strategies.
Little snippet version of what you've got for the educator module for those of us who are going to the schools as well. We don't know if their schools are instructing it or not, but enough of a snippet might cause their instructors to become more interested in doing so.
I would just suggest your clinic consortiums are probably a really great resource, just because we work, for us, the Garment Atlantic Consortium, Maryland, Virginia, and DC, and you capture all the PT and PTA programs in one shot. We're always looking for, resources, continuing ed, that type of thing, and I feel like a lot of the consortiums are a really great way to connect with a lot of programs at once.
Mariah from Oregon. Do we have permission to use these like slides and things that research that you have when we're teaching classes? Because I think a great way to get little snippets of this out is like when I'm teaching a lecture about something, I can like pull and use these as an example, then that would be a really good way to get information out as long as we have permission.
Permission granted and encouraged. That's the whole concept of the education model.